What if I told you Ottawa is secretly preparing for Alberta to leave Canada, and the feds blacked out nearly everything they wrote about it? This is the federal government's official response to my access to information request about Alberta's separation. Now, you might think that an almost entirely redacted document would give us nothing, but that isn't the case at all. We need only look at the senders and recipients on this email chain. For example, they looped in the top constitutional lawyer who helped stop Quebec's independence. But if you want to read what they actually said, good luck. Hey guys, Isaac Lammer here, and this might be one of the most important videos I've made so far on Alberta separation. Also, make sure you stay tuned to the end of the video for my new quote of the day segment. Let me know what you think of it, and feel free to make any other suggestions for further segments that I can use. But before we dive into my documents, let's take a quick glance at what I asked for in my access to information request. I asked for all legal opinions, constitutional analyses, or briefing notes prepared or received by the Department of Justice between January 1st, 2023 to May 21st, 2025, regarding the legality or constitutional implications of a potential Alberta independence referendum, the Recall and Referendum Amendment Act, Bill 54 in Alberta, federal or provincial authority to act on citizen-initiated referenda, the federal government's ability to respond to a successful provincial referendum on separation, and what I received was 6 pages of heavily redacted material. No legal advice, no summaries, not even visible subject lines in some cases. However, the Department of Justice backed up their redaction. In the response letter I received, they said, quote, "You will note that certain records or portions thereof have been withheld under Section 23, Solicitor-Client Privilege Information of the Act. While the contents were redacted, one thing they couldn't hide were the names." Also, by the way, the redaction in the department's justification of such confirms that this was a legal consultation, not just friends in the federal government emailing one another. The document confirms that Warren J. Newman, Senior General Counsel on Constitutional Law at the Department of Justice, was looped in, both as a sender and recipient of emails. If that name sounds familiar, it's because Newman acted as co-counsel for the Attorney General of Canada in 1998 when the Liberal government under Jean Chrétien shut down Quebec's secessionist arguments in the Supreme Court of Canada. The court had agreed with the Crown's arguments in its reference re Secession of Quebec judgment. Newman also authored the 1999 book, The Quebec Secession Reference, The Rule of Law, and the Position of the Attorney General of Canada, and has several academic articles on the Constitution. He's also spoken about this recently, for example, in a reflection on the 10th anniversary of the Supreme Court's decision. Newman wrote that, quote, "The Supreme Court of Canada confirmed that unilateral secession would be an unlawful act under the Constitution and a violation of the Canadian legal order, a revolution." One email shows a Justice Canada lawyer exchanging pleasantries with Newman, while the remainder of the correspondence is fully redacted. Correspondence dated from May 15th to May 23rd contains emails between the Department of Justice's Senior General Counsel on Constitutional Law, Warren J. Newman, Senior General Counsel on Indigenous Rights and Relations, Uzma Isanula, and Crown Indigenous Relations Senior Director, John Topping. Look, that's a constitutional dream team, and it means the feds are taking the Alberta situation very seriously and very quietly. Here's what makes this even more revealing: the timing of the emails. As I said, all 6 pages are dated between May 15th and May 23rd, 2025. But why is that important? Because May 15th was the day Alberta's Bill 54 received royal assent. And May 23rd was the day the Alberta Prosperity Project filed its placeholder petition application to hold a referendum on independence. That's not a coincidence. It shows that as soon as Alberta signaled it was getting serious about referenda, especially on separation, the federal government started preparing its legal response. They just don't want you to see what it is. And contrary to what you might have heard from the Alberta NDP, Alberta Premier Danielle Smith has not said she supports separation. She's made it very clear. She said, quote, "We would not be bringing forward as a government a question on the issue of independence. Instead, she passed Bill 54, allowing citizens, not politicians, to launch referenda, And she created the Alberta Next panel, which will explore what topics should go to a vote. If around 176,000 Albertans sign a petition, which is now the legal threshold, the province is required to hold a vote. So no, Smith isn't leading the charge for separation, but she's also not stopping Albertans from making their voices heard. She has pledged, however, a referendum in 2026 if the signature threshold is met. Therefore, the question might be actually whether Ottawa lets Alberta separate, or takes some sort of serious action to stop them from doing so, even if the legal grounds are met. So why is Ottawa redacting everything? Because they know what the law says. In 1998, the Supreme Court ruled in the Quebec secession reference that if a province votes for separation on a clear question, with a clear majority voting yes, the rest of Canada is obligated to negotiate. That's the scenario these federal lawyers are preparing for. And they're not just thinking about constitutional law, they're bringing in Indigenous affairs officials too. Because one of Ottawa's biggest potential roadblocks is the question of treaty rights and First Nations participation. Some treaty chiefs have claimed Alberta has no right to talk about separation without their involvement. But constitutional lawyers and the Supreme Court say something else. For example, Canadian Constitution Foundation legal counsel Josh DeHaas told True North, which as a quick reminder has no relation with this independent publication, he said, quote, "There is nothing I'm aware of that would suggest that First Nations people could prevent those discussions from taking place." And Keith Wilson, another expert in constitutional law, said, quote, "Respectfully, the Chiefs would benefit from legal advice. They don't have a vote on whether Alberta separates. They would, however, be full participants in any post-referendum negotiations, but they cannot block the vote itself." While the Alberta Prosperity Project first filed its placeholder petition in May, it specifically requested that Elections Alberta hold the application until Bill 54 was officially proclaimed. Well, it was recently proclaimed, and the petition now falls under the new legislation, which means the petition will have to gather around 176,000 signatures, a value derived from 10% of ballots cast in the last provincial election. The time to collect the signatures in person was also extended from 90 days to 120 days through the new legislation. However, the anti-separation petition is not so lucky. Former Conservative Cabinet Minister Thomas Lukaszuk did not wait to file his petition, which aims to ask Albertans whether the province should stay within Canada. And because he did not wait, Lukaszuk will have to gather 293,976 signatures, which is 10% of provincial electors on the post-election day list of electors. And again, this has to also happen within 90 days instead of 120. Therefore, he has a month less to gather nearly 118,000 signatures. More. And I know people have been throwing around that 600,000 number, but I asked Elections Alberta and they confirmed this to me. Even still, Alberta Prosperity Project leaders have called Lukaszuk's petition inadmissible. For example, General Counsel for the Alberta Prosperity Project, Jeffrey Rath, said, quote, "The question is not a proper referendum question to be used on a constitutional issue. Furthermore, to the extent that the question seeks nothing more than to preserve the status quo, it is not a suitable question for determination through a citizens' initiative referendum." Because the Alberta Prosperity Project deemed Lukaszuk's petition as a mischief application, it asked Elections Alberta to prioritize the approval of the pro-separatist question ahead of its counterpart. Although Lukaszuk's application was approved on June 30th, but remember, it falls under those old rules, so it will be much, much, much harder to accomplish. The Alberta Prosperity Project continues to host town halls across the province as it prepares to launch its official campaign under the lower threshold. Remember, the Alberta Prosperity Project's question that will be on the petition on the referendum is, quote, "Do you agree that the province of Alberta shall become a sovereign country and cease to be a province of Canada?" So let's go through a quick recap here. Ottawa's lawyers are discussing Alberta separation. They're consulting the same people who fought Quebec's independence bid. They're redacting nearly everything under solicitor-client privilege. And they started doing it the exact same week Alberta passed Bill 54 and the petition application was filed by the Alberta Prosperity Project. If this wasn't serious, they wouldn't be hiding it. And if they didn't think Alberta was capable of leaving, they wouldn't be prepping the legal playbook in secret. The legacy media won't show you this, and frankly, they probably don't even know about this, but I will, and I do. If you found this video informative, please subscribe and share it. I've got more on Alberta's future and what Ottawa is trying to suppress. Before we wrap up though, here's the promised quote of the day, which I actually recently stumbled across online and I found it very fitting. given our current federal government's spending habits, which, as you all know, are well out of control and, unsurprisingly, worse than former Prime Minister Justin Trudeau. My name's Isaac Lamoureux. Thank you for watching, and God bless, and enjoy this ancient but perhaps relevant now more than ever quote.
Since then, he has blamed to the people for inflation OPEC. He's blamed the Federal Reserve System. He has blamed the lack of productivity of the American people. He has then accused the people of living too well, and that we must share in scarcity, we must sacrifice and get used to doing with less. We don't have inflation because the people are living too well. We have inflation because the government is living too well.